Hello everyone, this is The Last Word and I'm Maria Shakil. Not all privately owned properties qualify as community resources that the state can take over for the common good. That's what the Supreme Court today has said in a landmark verdict. It was a 9-judge constitution bench led by Chief Justice of India D.Y. Chandrachud that delivered the judgment on this vexed issue with an 8-1 majority. 3 judgments were authored. The Chief Justice, in fact, wrote one of them himself and also for his 6 colleagues. Justice BV Nagarathna wrote a concurrent one, but a separate judgment was written by Justice Sudhanshu Dhulia, who dissented. The case relates to Article 31C of the Constitution that protects laws made by the state to fulfill directive principles of state policy, which are the guidelines the Constitution lays down for governments to follow while making laws and policies. And among the laws that Article 31C protects is Article 39B. Now you will ask, what is Article 39B? Article 39B lays down that the state shall direct its policy towards ensuring that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. Remember, in 1977, a 7-judge bench had ruled with a 4-3 majority that all privately owned property did not fall within the ambit of material resources of the community. In a minority opinion then, Justice Krishna Iyer held that both public and private resources fell within the ambit of material resources of the community under Article 39B. So what does today's judgment mean for you and me? Talking about the big highlights of it is Kapil Sankla, who is here to decode the verdict for us. Advocate Kapil Sankla, thank you so much for speaking to NDTV. Help us understand, what does it mean for you and I, for citizens?
What happens when the government acquires the land or takes over your property and then says that, all right, not me, but why? Because this is what public-private partnerships are all about. Will give the money to you, but does not give the money to you. Then you will be fighting on 2 fronts. You will actually be fighting against a private party, which is unfair, right? The second aspect, what is fair compensation? Because what could be fair for the government is not fair for you. So whether the compensation will be what is the current market rate or the government's rate as per its whims and fancies. And thirdly, most importantly, you see, this is also what Justice Chandrachud and the majority bench stated, that there was a particular view, which also was of Justice Iyer's view, which was predominantly a socialistic view, saying that all assets are common pool, the government can take over anything because it actually belongs to the government. But this view over the years have been whittled down. And now we actually belong to a society which is a very open society, a very cosmopolitan society, a very capitalist society where it is okay to make money, it is okay to show off your wealth, it is okay to to create assets, etc. Now, what would happen to a private party who's created those assets but cannot distribute it amongst his own children or grandchildren? That would be unfair to the person itself. And therefore, what the Supreme Court has stated, that the directive principles, and just to digress, the first part of it is this, that the right to property was our fundamental right, is no longer our fundamental right, it's a constitutional right. So it's been downgraded. Having been downgraded, the Honorable Supreme Court has still protected it in a number of judgments. What the Maharashtra government was saying is that there are directive principles which are a part of the constitution. In terms of the directive principles, we can take over anybody's land. These are material resources because this is for common good. But the Honorable Supreme Court rightly stated, and stated in terms of the Keshwananda Bharati judgment, which is supposed to be the Kohinoor of our, the constitutional law, 13-bench judgment, which basically stated that there are 2 parts of the constitution, one that can be changed, and the second is the basic framework that cannot be changed. And that itself is very important, that even the directive principles or the legislature cannot really create something to change the fundamental rights or the fundamental part of the Constitution of India. And one of the fundamental parts is this, albeit I said it is not your fundamental right, but a constitutional right, that only in certain circumstances, and those circumstances would have very heavy checks and balances, very heavy checks and balances, only under exceptional circumstances where it is shown by cogent reasoning that a certain land bank or a parcel is required for the government for common good, no property can be taken away. And that, in my view, is the right view.
Okay. Mr. Sankla, for a family or a group of people who are challenging their land being taken away by the court, by the government, for them, this larger good definition now under scrutiny or clarity emerging over it, what does it mean for them after today's judgment?
So, to answer that, we go back to 39B, which is the crux of what the government's argument was, stating that, and I'm paraphrasing, that the state can, in particular, in the directive policy, can create a policy that the ownership and control of the material resources of the community, and as I said, the catchword is material resources of the community, are so distributed as best to subserve the common good. The main contention was whether the term material resource under the Article 39B can be interpreted to mean any resources capable of generating wealth. And the Honorable Supreme Court has stated no, it cannot be. It can only be under exceptional circumstances. So not only we revert back to the previous position that the land acquisition can only be for particular purposes, those purposes have to be shown by the government, and there has to be fair compensation. And the second part of it is that not every land is a material resource. So therefore, as I stated, your assets, your land bank is safe unless the government shows by particular reasoning that a particular land bank is required. For example, to create a highway. For example, there is a forest, and the forest is required to be taken over by the government because of its unique flora and fauna, or certain other reasons. But those reasons are exception to the rule. Your assets are not material resources under 39B, which is very, very clear, which the Honorable Supreme Court has stated, and also stated that Justice Iyer's judgment, which was more socialist in nature, they did not, of course, say that. Justice Iyer's judgment, which was more socialist in nature, saying that every land, every parcel belongs to the government has first right, is not the right view, which basically concludes your land is your land unless exception shown. Not every land is material resource. The government cannot take over your land. And if it does, it has those checks and balances which have been held by the Honorable Supreme Court in plethora of judgments, including pertaining to land acquisition, including pertaining to disclosure of the reasoning why the land is required, and that you can challenge the setback before the Honorable Supreme Court or before the High Court, as the case may be.
All right, Kapil Sankla, I appreciate your time. Thank you for breaking down that crucial judgment for us. Let me also bring in other panelists now. Preet Mittal is a senior advocate of the Supreme Court. We also have Declina Calden, who is someone who is a petitioner also in the land acquisition case. Mr. Mittal, I want to understand from you, because this is a judgment which will have long-term implication. And what is becoming clear here is that citizen is supreme and the government cannot really dictate beyond a point, but at the same time there is that distinction which is being made about what was seen as mindless state control.
So thank you, Maria, for having me over at the start. And what has actually been done is Article 39B has been interpreted by the Supreme Court. And the phrase which was there is material resources of the community has been taken note of. And when it says material resources, it of course includes everything, but then it says there's no classification to it. And one is that the community, it has to be a community resource. So the purpose of community usage, if it is a resource, then of course it can be taken off, but a private property of a personal nature, no. Now, for instance, I'll give you an example. Let's say mineral and mines, or let's say oil and natural gas, or electricity, petroleum. I'm just giving you, it's a non-exhaustive list, but I'm just giving you certain examples. Now, in such areas where private control or private dominance may not be in the interest of community, that is where the government is permitted in 39B, Article 39B, to take over those assets. But individual assets, which are not scarce in that sense in nature, is the government would not have a say in it for the purpose of takeover.
Okay. Ms. Calden, as someone who is a petitioner in a land acquisition case, how are you looking at today's judgment? It upholds your right? Dekila, if you can hear me. Okay, we will try and connect that line again with Dekila in just a bit. But Puneet, one thing is clear, that this landmark judgment has overruled a judgment which was given 5 decades back in the Indira Gandhi nationalization inspired era. So there is a shift in policy which is also being initiated with this judgment.
See, this judgment actually, to be very fair, has only decided a reference. And actually the issue with regard to acquisition of property, because this arose from Maharashtra, and this arose about the properties prior to 1st of September 1940. And it was a peculiar case because 16,000 properties were in dilapidated state and they were dangerous. And they were not being able to protect the properties, and it was dangerous to live into those properties. Now that issue, whether that acquisition was correct or not, is going to be decided by the appropriate bench. Now it is only decided with respect to implication of 39B of the Constitution of India, nothing more. Now, as far as the nationalization bit is concerned, if you look at it, as I said, and I'm repeating it, when we look at those assets, which I mentioned a little while back, those assets are of community importance. Those assets, if come into private control and which are scarce in nature, that is where the government is coming into play. That is where the acquisition is considered to be correct, but not in any other case. Not in cases where private houses are there per se, where people are residing into and using it for personal use, and no community purpose is being served, or distribution of those assets is not serving any community purpose. That is not covered by 39B. That is what the Supreme Court.
Okay, so let me bring in Dekila again, and if you can hear me now, my question is, as someone who is a petitioner in a land acquisition case, how do you look at today's judgment?
My land acquisition case happened in 2010. That was before the new LAR acquisition happened. All right. So when we approached the court, we did not want to part with our land. This is from my father's maternal side, ancestral property. So we were not ready to part with the land, being a tribal, community from the state of Sikkim. If this today's verdict was there then, maybe the forceful acquisition would not have taken place, and we would have been heard, and a proper process would have been followed, instead of the land acquisition commission, the district collector, following left, right, and center the acquisition sections, and then acquiring the property and giving to a hydropower project, when there are already, I think, 29 hydro projects sanctioned in the state of Sikkim. And if we were given a chance to hear, maybe things would have taken a better course. And
okay, Dekila,
I feel like
and what about the compensation? Because we have often seen that in most of these cases, the compensation is also not timely.
Yes, sadly, when a government acquires the land, in my case, when the acquisition took place, our market rate is 30 rupees per square feet, which right now, after fighting for 15 years, it has increased to 95 rupees. And in today's time, I don't think, you even get a handkerchief with that amount, and you're talking about a land. So compensation, well, we haven't received compensation as such, because this is the third time we got an order from the Supreme Court, and the private company was supposed to pay the first installment by 31st of October, and they still haven't paid the installment. So compensation is, I think, we're still trying to.
Okay, so Puneet, I've just enough time for you. You heard a case study of this nature, and there would be countless such land acquisition petitioners all across India. My question to you is, does it really apply retrospectively?
No, so is that question?
Yes,
so
Puneet, that's for you. That's for you.
So, insofar as the compensation part is concerned, actually, that's an administrative exercise carried by the land acquisition director. Now, there is a procedure prescribed therein that if you're not satisfied with the compensation which you're getting, you have a process of appealing, and of course, if you're not getting the compensation on time, then you have a process of executing and approaching the courts and so on and so forth. So, compensation, I mean, how many years back that you got, you still have a remedy against the quantum of compensation that you've got and the government has awarded. So, it's certainly an appealable process for which you will have, of course, have to approach the court.
All right. So,
I mean,
thank you so much for joining us, Puneet Mittal there, and Dikila Calden for sharing your story. Let's try and understand the economic implication of this judgment of the Supreme Court today. We have economist Gurcharan Das joining us on the last word now. Sir, thank you so much. You know, as someone who is an economist and also a policy analyst, how do you look at today's judgment, and do you think it makes a distinction between what was seen as a welfare state versus socialism, or a distinction is being made between a welfare state as opposed to some kind of a Robin Hood style economics?
Right. Well, it's clearly the Supreme Court judgment on private property is a landmark judgment. It's an 8-1, a 9-bench judgment. And overall, it strengthens the fundamental pillar of classical liberalism and the market economy, rather than a socialist or communist economy. And it's a major ideological change, a change that had begun in our country from 1991 onwards. And there have been sort of judgments, minor judgments, which have come along the way, where the judges have interpreted in this manner. But now that it's up here in a big judgment of the Supreme Court, I think what it does is that the state now cannot seize a person's private property. Before, you know, private property had been a fundamental right. Then during the Indira Gandhi period and a judgment like Krishna Iyer's, it had really been reduced to a constitutional right. Now we have restored it back to a fundamental right. And as I was saying, the state will have the onus will be on the state, the burden of proof, rather than on the citizen for taking over a property. I mean, it's still, if there's a road to be built and your house is right smack in the middle of the road, the state will be able to take it, but they'll have to go through a process. They'll have to prove that it cannot be, it has to go only from this point to this point, and they cannot go around your house. But what it does is, so it won't stop acquisition for the public good, but it just adds now they'll have to definitely pay market compensation. If the government, before, they used to expropriate property without full compensation. So it's actually a very big a big mental change, a mindset change. And as I said, that the idea of during Indira Gandhi's time, when this interpretation was on, in fact, it was the first cases were really during Nehru's period, when they wanted land acquisition it was against zamindari, and people accepted, big zamindari lands, etc. And so there wasn't a lot of hullabaloo. But now, over time, people realize that even the poor have a home, a property, and you can't just take it away. It's not just the rich. So the reality is, frankly, that uh, the classical liberal in me is delighted. And frankly, now I see the other mischief they did during Indira Gandhi's time, which was to insert socialism into the constitution. It wasn't there originally. They inserted so then let's hope there'll be a judgment which will remove socialism.
Okay, Gurcharan Das, there is one reading of this judgment that it is trying to understand what is private resources of individuals, and can that be taken for a purpose of redistribution? How do you view it?
Well, exactly. That before the state didn't particularly make any distinction. That the principle under the Justice Krishna judgment was that all property of all individuals ultimately belongs to society. And therefore, the society or the government has a right on it. And this was against that collectivist mentality, the communitarian mentality of Marxism. Now what will happen is that there will be a lot more burden of proof on the state to prove that this particular piece of property that you are taking away from me, that is truly needed for a public purpose, and they will have to, it'll be, as I said, the burden of proof will fall today. It's the long-term implications of this. I mean, in immediate terms, as I said, I'm not sure it'll have a great impact, because for the last 30 years, since 91, India has been moving, and judges have also been moving. So in practical terms, you're not going to have any immediate impact. But what it means is that we have finally broken with the old communist, Marxist, socialist ideals, which were very powerful and which still prevail in the bureaucracy, amongst the people, because no one has, frankly, unlike in UK, in the US, in China even, Deng Xiaoping sold the reforms, the market. Margaret Thatcher used to spend 80% of her time selling the reforms and only 20% doing the reforms. And similarly, Ronald Reagan. So the market is not an easy thing, to sell. The reason is, and that's why Adam Smith called it an invisible hand. The reason is that millions of people working for their own profit ultimately lead to society's lot improving. And it's not an easy thing to understand how that is. It's a what he called the invisible hand. And no politician in India, that's our big failure. No politician. Manmohan Singh, Narasimha Rao, Vajpayee, all these people did great reforms, but they have not sold them. Mr. Modi, he hasn't gone and sold reforms to the people. So people don't know, the bureaucracy doesn't know, and so the fact is that this is, I hope that this judgment will at least start a debate in the country.
Okay. Gurcharan Das, my last question to you, sir. The government of West Bengal had also supported the arguments of Union of India and also Maharashtra. Do you think states are increasingly realizing that this is the way forward?
Yes, I mean, you're absolutely right. Kerala and West Bengal still very large because they were Marxist-run governments, people have not yet understood the importance that you can't have a Marxist, communist type economy, a command economy in a democracy. And if you want to remain democratic, then you have to give economic freedom to the people. And this means private property has sanctity. And that's the fundamental idea in the system. And even a poor person has a shirt on his back. And that shirt, you can't just take away his shirt. It's his property. So everybody has property. This is just a basic respect for the human freedom.
Yes, absolutely. I think it's the individual rights that has won today. So thank you so much, Gurcharan Das, for breaking that down for us, for decoding this entire Supreme Court judgment, which is certainly being seen as historic and landmark in many ways. That's all from me. We are putting out this entire discussion on ndtv.com. Thanks so much for watching.